Mediation, moving from an alternative to an obligatory form of dispute resolution. Go on to the next slide, please. Now, before beginning with this, we all need to understand, where does mediation stem from? Is it something which has come out in the modern form, like how arbitration has? No, that's not the case. As we all know, the concept of mediation is and deeply rooted in our country. In light of the history of mediation in India, methods that were congruent to the modern alternative dispute resolution mechanism can be traced back to centuries prior to the advent of British in India. The era constituted informal panchayats that were used as an institution to resolve disputes between the parties. In this form of mediation, the revered elderlies of the villages or in business communities, which were referred to as Mahajans, assumed the role of mediators and resolved disputes. This was an effective mechanism because A, obviously it is the most cost effective, and also the elders had massive social capital and the social control. Their decisions were respected and abided by as a matter of cultural obligation, which gave their decisions binding value. Now we have grown into a country of 1.25 billion people. That's like 125 crore people. And with liberalization and globalization, there is tremendous economic growth. All this has led to explosion of litigation in our country. In the recent forms, since the onset of the pandemic, we've also been seeing ODR, which has come in, that is online dispute resolution. So the claims of people are just increasing by the day. Though our judicial system is one of the best in the world, and this I can say because there's nowhere in the world where you will see a lawyer having 10 cases or 20 cases in a day. Like I worked in, or interned, I would say, in Blackstone Chambers in the UK. There, a barrister would work on one case for the entire month. Though that does deliver quality, but it is something which cannot be accepted in India because of the quantity and the sheer volume of cases that is there. Despite all this, there are still crores of cases that is pending. Now, a lot of people say that this criticism on account of long delays in the resolution of disputes in the court of law in our country, but you got to accept how it is. And our courts are changing and accepting and trying to expedite the resolution of disputes. Like if you see the moment our new Chief Justice, Mr. U. Lalit, took over, probably I think in one day he disposed of, I think, more than 2,000 cases. That is a huge development. So we can see such things with the help of technology, how we can dispute, but not brushing away from the topic. Let's get back. Now, an honest litigant is wary of approaching the court for a decision for his or her dispute. Hence, we have turned to alternative dispute resolution mechanism. The legislature realized this back in 1999, and by the Code of Civil Procedure Amendment Act 1999, amended Section 89 of the CPC with effect from 1st July 2022, obviously prospective effect, whereby mediation was envisaged as one of the modes for settlement of disputes. The amendment in Section 89 was made on the recommendation of the Law Commission of India and Justice Malimat Committee. It was recommended by the Law Commission that the court may require attendance of parties to this suit or proceeding to appear in person with a view to arrive at an amicable settlement of the dispute between them and make an attempt to settle the dispute amicably. Justice Malimat Committee recommended making it obligatory for the court to refer the dispute after issues are framed for settlement either by way of arbitration, conciliation, mediation, judicial settlement through Lok Adalat, and other forms of dispute resolution. It is only when the parties fail to get their dispute settled through any form of ADR that the suit could proceed further. Thus, Section 89 was introduced to promote the ADR. Now, we obviously know that the Malimuth Committee's recommendation wasn't taken on a writing on a stone, but yeah, they moved a bit away from it and captured the essence of it by just including it in Section 89. Before we go further, we should ask ourselves what is mediation. As Mr. Bhumik rightly pointed out, an ounce of mediation is equivalent to a pound of arbitration and a ton of litigation. I hope I'm audible, right? Ms. Bhumika?
Yes, sir, you are.
If any issues, just please highlight it.
No, sir. Also.
Please call Anurag. Now, as we all know, that mediation is one of the most effective modes of ADR that is available to parties who wish to avoid courts and settle disputes amicably. It is a process wherein a neutral third party facilitates negotiation to reach a definitive settlement. Mediation differs from arbitration in a manner wherein, unlike arbitration, it does not involve the mediator making the decision. Mediation can be initiated by the parties or may be mandated by legislation, the courts, or via contractual terms. Like when I say by the courts, you guys would be remembering the very famous case of Ayodhya, where they referred them to mediation, I think 2 or 3 times, to arrive at a dispute. Because sometimes the nature of the dispute is as such that either the damages cannot be properly evaluated or the question of fact cannot be decided. And like I said, looking at the sheer quantity of cases in our thing, the courts cannot give away so much time to one case because then it will lead to discrimination. How is that one case is more important than the other case? Just because it may involve crores of rupees or hundreds of crores of rupees does not take away a common man's right to litigate and having been given the same amount of time if his disputes are of lakhs of rupees. The court does not distinguish, or the law does not distinguish us that way. Now, mediation can be initiated by the parties or may be mandated by legislation, as I said. Henry J. Brown, in his book, has defined mediation, and I quote, as a facilitative process in which disputing parties engage the assistance of an impartial third party, the mediator, who helps them to arrive at an agreed resolution of their dispute. The mediator has no authority to make any decisions that are binding on them, but uses certain procedures, techniques, skills. By skills, I mean sympathy, empathy, socio-economic understanding to help them to negotiate an agreed resolution of their dispute without adjudication. Now, you all might be thinking, what is the difference between mediation and conciliation? Please, if you can go on to the next slide. Yeah, like I said, conciliation is whereby it is a process by which the parties to a dispute are held by a neutral and independent party to reach a mutually acceptable settlement. It is a responsibility of the parties themselves to reach an agreement, whereas in mediation involves a further step. The mediator not only conciliates, but makes their own recommendation. But in light of, as we all know, the Mediation and Conciliation Act of 1996, I'll show you how they have gone through as to what a mediation is. Now, if you look at section 67 of the Act, of the Arbitration and Conciliation Act, the lines have become a bit blurred. The definition which I told you is found in International Arbitration Law and Practice by Mauro Rubino Sammartano, the second edition. Now, this is a very revered book and an authority in itself. But in our Act, the legislators have gone a bit further, and I'll quote the role of conciliator, which is found in section 67 of the Act. The conciliator may conduct the conciliation proceedings in such a manner as he considers appropriate, taking into account the circumstances of the case, the wishes the parties may express, including any request by a party. The conciliator may hear oral statements and the need for a speedy settlement. The conciliator may at any stage of the conciliation proceedings make proposals for a settlement of the dispute. Such proposals need not be in writing and need not be accompanied by a statement of the reasons thereof. Now you guys will be thinking, isn't this the same thing what he just said, what the mediator does? Doesn't the mediator take a step further and give his own suggestion? But that is what has happened. The anomaly has maybe not yet been pointed out, or maybe adjudicated upon, and maybe it has just become a synonym word in a way. Like until the advent of the Mediation Act, which is right now just a bill, Mediation Bill of 2021, when it comes out, maybe we'll have a more dearth of case laws, which will maybe clear this anomaly between us. Moving on, where do we find this mediation, and why has it become such a central topic? Now this is obviously the most central topic for commercial lawyers. And I see many students out here. If you want to be a commercial lawyer, you have to digest this one act. That is the Commercial Courts Act of 2015. The next slide. Now, the Commercial Courts Act of 2015, if we go to section 12A, now let me make it clear. Now, the Commercial Courts Act of 2015, when it came into being, it was only applicable to cases which had a claim value of 1 crore rupees. But over the years, sometime in 2017-18, that thing has been brought down to 3 lakh rupees. So any commercial case above 3 lakhs, which I reckon in the modern economy, 99% of the cases are more than that. So this act does come into place. And the moment this act comes into place, we have to, before instituting a suit, have to look into section 12A of the Act. I will quote section 12A of the Act, which comes under the heading of chapter 3A, pre-institution mediation and settlement. A suit which does not contemplate any urgent interim relief under this Act shall not be instituted unless the plaintiff exhausts the remedy of pre-institution mediation in accordance with such manner and procedure as may be prescribed by the rules made government. Now, like I said, I emphasize unless there is an urgent relief, like suppose the assets are going to be dissipated, or the money is going to vanish by tomorrow morning, or this building is going to fall, you have to follow this procedure. Earlier, people thought that this is taking away people's right, and they used to just file the case, taking this as a directory and not a mandatory legislation. And with this comes the Commercial Courts Pre-Institution Mediation and Settlement Rules of 2018. Now, if you have a bare act, you can find the same towards the end of this, which lays down the procedure as to how you have to file the same, where you have to file the same, and the timeline which is laid down for the mediation council to legislate upon, to take care of the mediation proceedings. Now, like I said, people were just filing cases and themselves come into a conclusion that this is declaratory and not mandatory because of various reasons, which may be legitimate, maybe not. I'm no one to decide. But yeah, that was the case. Unless the matter reached the Supreme Court and was finally put to rest by the recent decision of Patel Automated Limited versus Rakeja Engineers Private Limited, whereby the apex court held that pre-institution mediation is mandatory and non-adherence to it will make the plaintiff liable to be struck out under Order 7, Rule 11 to be barred under law. Now, the two-judge bench of the Supreme Court in the earlier mentioned decision considered a question, which was whether the statutory pre-litigation mediation contemplated under the, as earlier mentioned, Section 12A of the Commercial Courts Act of 2015, as amended by the Act of 2018, is mandatory, and whether the courts have already not allowing applications filed under Order 7, Rule 11 of the CPC to reject the plaints filed by the respondents in these appeals without complying with the procedure under Section 12A. The bench concluded that, and I quote, having regard to all these circumstances, we would dispose of the matters in the following manner. We declare that Section 12A of the Act is mandatory and hold that any suit instituted violating the mandate of Section 12A must be visited with rejection of the plaint under Order 7, Rule 11. This power can be exercised even suo motu. So it's not necessary for anyone to make an application. If the judge ought to feel so, not even if he ought to feel so, he may reject the plaint. And they further say, we, however, make this declaration effective from 20th August 2022, so that concerned stakeholders become sufficiently informed. Thank God for that. Still further, we, however, direct that in case plaints have been already rejected and no steps have been taken within the period of limitation, the matter cannot be reopened on the basis of this declaration. Still further, if the order of rejection of the plaint has been acted upon by filing a fresh suit, the declaration of prospective effect will not avail the plaintiff. Finally, the plaint is filed violating Section 12A will not be entitled to the relief. Now, again, this has created some anomaly because if you step into the field of litigation, sometimes you have to take in strategical decisions because sometimes the client cannot afford making an application and again. And sometimes when you know a matter is sub judice, you would wait for the court to take a decision. What if the decision was that it is not mandatory? Then the people would have just filed the case normally. But now they have made it mandatory and said the matter cannot be reopened. So you are impinging upon their right and suddenly making it obligatory, right? Suddenly make it otious. So this is an anomaly. I'm pretty sure it is going to go further to a review petition because this is just, as I said, decided by a two-judge bench. Now, going further, the main arguments made in support of the contention that Section 12A of the Act is not mandatory was that there was no penal provision for non-compliance, and hence it should be construed as directory and not mandatory, which is true. Even to be honest, that makes sense. The court rejected this argument by inter alia analyzing analogous provisions of Section 16(9) of the Indian Partnership Act and Section 80 of the Code of Civil Procedure. Neither of the sections provide for any penalty for the suit brought in contravention of them. The Supreme Court further observed that even though no legal right of the defendant is affected due to non-compliance of pre-institution mediation, the real object of the law should be viewed in the broadest sense. The object is not to be viewed narrowly with reference to impact of the parties alone, but to the wider object of the general public, and also with the main motive of declogging the courts. Like in the beginning of the webinar, I would have explained to you the crores of cases pending. So they are finding out ways. The chief advantages and highlight of mediation, according to the judges, is that it is a win-win for all sides if the mediation is successful. What about the mediation is not? Show a comparative analysis of what's the situation in the UK, how we call it, the United Kingdom. Now, as you're all aware as students of law, that the Indian legal system is part of common law legal system, and common law continues to be the existing law by virtue of Article 272 of the Constitution of India. It is therefore axiomatic and profitable to refer to the development trajectory in the United Kingdom. I will start off with the case of Halsey versus Milton Keynes, General NHS Trust. The question before the court was as sanction against the winning party on the ground that it had refused to mediate. It was held that the court has the power to deprive a winning party of some or all of their costs on this basis. But the burden is on the losing party to demonstrate that the normal rule should be departed from. That is, costs follow consequences. In other words, the winning party is always entitled to costs. The situation in India, though on paper it is there, it is not followed. You would see majority of the judgments where the court would be that parties to bear their own costs. Because it is only on paper, but costs being such a disproportionate sometimes in India, it's not avoided. But coming back to the topic. To justify such a departure, it must be shown that the winning party acted unreasonably in refusing mediation or ADR generally. It will be arbitration, conciliation, and so on and so forth, by reference to considerations set out in that case. The judgment in this case categorically opposed the imposition of any obligation on the parties to refer their matter to an ADR mechanism. Let me repeat that sentence. The judgment in this case categorically opposed the imposition of any obligation on the parties to refer their matter to an ADR mechanism. Next slide, please. Now this brings us to a question. That is next slide, please. Is compulsion of mediation an unacceptable restraint on the right of access to justice? A constitutional point arises whether the parliament has power to mandate parties to submit their disputes to mediation against their will, since right of access to justice is a fundamental right which is enshrined in Article 21 of the Constitution of India. The Supreme Court, in the case of partial automation, did not consider the issue in the context of right of access to justice, which is a fundamental right as held in many cases. This, to name the first, is PLR projects versus Mahanadi coalfields. The bench observed, and as we all know, the Supreme Court judgments, even the arbiter is binding. Even though that judgment which said that was itself an arbiter, but yeah, we don't want to get into that. That will open another floodgates. Now, the jurisdiction of a civil court can be ousted. In other words, there is no fundamental right with anyone to contend that he has a right to file a civil suit which cannot be taken away. It is one thing to encourage the parties to agree to mediation and even to encourage them in the strongest terms. It is another to order them to do so. It seems to us that to oblige truly unwilling parties mediation would be to impose an unacceptable obstruction of the right of Strasbourg has said of the European Convention of Human Rights that the right of access to a court may be waived, for example, by means of an arbitration agreement, but such waiver should be subjected to particularly careful review to ensure claimant is not subject to any constraint. Like I'll give you a slight analogy, after this. In also the case of Dewar versus Belgium, if that is the approach, it held, if that is the approach of the European Convention of Human Rights, European Court of Human Rights, to an agreement to arbitrate, it should follow that compulsion of ADR would be regarded as an unacceptable constraint on the right of access to justice. On this, the White Book clearly says, White Book, to be clear, is sort of like the procedure code which is followed in the UK. It is called the White Book. The hallmark of ADR procedures, and perhaps the key to their effectiveness in individual cases, is that they are processes voluntarily entered into by the parties in dispute with outcomes, if the parties so wish, which are non-binding. Consequently, the court cannot direct such methods to be used, but may merely encourage and facilitate. This also brings me to the position in India. Like, I don't know, you guys are just students of law who have just begun, or you might be in your 4th or 5th year. That will soon. This will talk you sometime in between 2016 and 2018, or like I would say prior to 2018. What people would put in their arbitration agreements, and I've seen this a lot, is that by agreeing to arbitrate, you're putting your right to go to court. Sorry, can you mute yourself, please? Okay. Yeah. Yeah. So like I was saying, sorry. Okay, yeah, sorry. So like I was saying, back in the day, you would see this thing where people constrain the parties to not go to court if you have signed this agreement. And the court rightfully struck this out as being, as coming as, and I'm just quoting off my head, that a contract which takes away your civil rights is not allowed. It is absolutely not in power with anyone to by way of a contract to take away your civil rights of approaching the court. This is your right, which has been enshrined in the Constitution of India. Now, without drifting away much, coming back to another case, which is Thakkar versus Patel. Yes, you might be thinking this guy is talking about UK, but referring to Indian case laws. I mean, I can't help it that Indians everywhere these days. And we do form a major part of case laws in the UK as well. Now, in the case of Thakkar versus Patel, as decided by the European Court, is an example of a party frustrating the mediation process. The claimant attempted to arrange a mediation, but the defendants procrastinated and delayed for so long that the claimant lost faith in the process. This was found to be unacceptable behavior on the part of the defendant, and a substantial cost order was made against them. It is reasonable to conclude that even frustration of mediation process invites cost sanctions as against any barrier to approach the court of law. Next slide, please. Now, in conclusion, I have a lot to say. Like, though we would be here, the court has highlighted the benefit of mediation and the object to be achieved behind making pre-institution mediation mandatory. The impression is that it has overlooked the issue of its implementation at the ground level. There is no doubt that there is a dearth of experienced mediators and notified mediation centers in the country. And more so by reducing, like I earlier said, they've reduced it from the claim amount from 1 crore to 3 lakhs, so whereby this act kicks in. The floodgates have opened up. The timeline which has been mentioned in the rules, which even though, like I'm saying, this is even before the institution, when you go and fill the form and the claim, you give it to the thing, to the concerned registry. The rules, and I quote, will say, at Rule 3(2), the authority shall, having regard to the territorial and pecuniary jurisdiction and the nature of commercial dispute, issue a notice as per Form 2 specified in Schedule 1 through a registered or speed post and electronic means, including email and the like, to the opposite party to appear and give its consent to participate in the mediation process on such date not beyond 10 days. Now you might be thinking, oh yes, said 10 days, 10 days is not much of a time. But then let's come to 3, subsection 3 of Rule 3, where no response is received from the opposite party, either by post or by email, the authority shall issue a final notice to it in the manner as specified in sub-rule. Now the timeline is not mentioned here. We may assume the timeline which is mentioned about 10 days, but who knows? Some people might say no, unless it is expressly stated, you can't take it. There's just a reasonable time that you're going to take it. So in my experience, what I've gone through lately, it takes minimum 30 days for even the arbitration, for even the mediation to begin with. And as we all know, the mediation timeline is first 3 months, that is bring us to 180 days, extendable upon mutual consent to 5 months. Not by 5 months, total limit of 5 months. Next, with the overflow of references to mediation towards these mediation centers, it actually seems, according to me, impractical to expect them to comply with such strict timelines. It is axiomatic that by making pre-institution mediation mandatory, that too which should be in accordance with the rules and when the necessary infrastructure is not in place, would lead to nothing but delayed justice. And it's a very famous and old phrase you all would have heard: justice delayed is justice denied. And why is that? I'll tell you in a bit. Though the intention of the legislature has been to declog the courts and reinforce the principle that the litigation should always be the last resort, the prescription as mandatory seems to be harsher than required. And as students of law, we should always, when such an obligation has been referred, we should always take ourselves back to the Constitution and say, is this restriction necessary? What are the objects for these restrictions? And can these objects be achieved by a less harsher restriction? This is something which we should ponder upon, though not discuss in the case, but yeah, eventually if a review petition is filed, this question is axiomatically going to be discussed. Because as I explained earlier, the same object of amicably resolving the dispute can be achieved by cost consequences, which has been going successfully in the UK as well. And by making certain changes as well, by making a national list of mediators and not necessary to go through mediation centers. As long as you have a proof that you have gone through the mediation through a listed mediator, it should suffice. These all recommendations have been made in the mediation bill, not to worry, but when it will come out, again, God knows, hopefully soon. Now, in this case, again, in the partial automation case, they have undoubtedly acted with the intention of declogging the courts, as I said, but the consequences seem too harsh. The judgment also seems to be per incurium, since it doesn't consider the impact of mandatory pre-institution mediation to impinge upon the right of access to justice, which is enshrined under Article 21 of the Constitution of India. The compulsory mediation is contrary to the policy of mediation itself, which is supposed to be voluntary. Moreover, the mediation centers will be clogged with references affecting the genuine mediation cases. So in a way, you're trying to clean a clog by clogging something else. Does that seem logical? Who knows? The Indian Parliament should therefore, in my view, intervene and clarify by passing a validating act or rule or notification that pre-institution mediation is not a mandatory requirement. We hope that the parliament intervenes and or a larger bench of the Supreme Court will look into this matter. But till then, it is safe to say that in the Western world, mediation forms part of an alternate dispute resolution. But in India, it has now been recognized as a precedent. A conditioned precedent to litigation. And one more issue I would like to highlight is by making mediation mandatory, like as commercial lawyers, numbers should be our top game. Mediation will obviously make it mandatory, and like you have to always act in the best interests of your client. It's not always winning the case. It's also having the least amount of damages maybe to be paid, or protecting the client's rights, even though he may be wrong, or he may be considered to be wrong by the court, but to narrowing the claims down for him as much as possible, because that may be winning for him. Or sometimes it is strategical, where the clients may be delaying payment. Like suppose it's a case of, I'll give you a simple example of, I was doing a case where the claim amount was of 1,000 crores with an interest of, that time it was written 24%, but as we all know, there is no obligation, or there is maybe hardly any case law where interest has been awarded fully to anyone. No one gets full interest. And even though you have written that, no one gets fully, maybe in some cases under the MSME, though they say that you get up to 3 times of the normal rate, how much it is imposed, it's again a discretion of the court. So in such scenarios, what happens is, like this claim amount here, was I was saying like 1,000 crores going on since 2012 and compoundable at 24% interest. And by the time of 2019, the interest itself had become not to more than 1,000 crores. Are you telling me that the court is going to award you this much? No. But also look at the person's perspective. Like the client had to pay 1,000 crores, but he got it delayed from 2012 to 2019. By that, we all know how money works. Money makes money. We want to be clear with that. By delaying this, he got to play with that money, or like to use that money in other sense and make another 1,000 crores for himself and give and pay off the damages. So a lot of people would love, like if I know that, yeah, I've wrongfully terminated the contract or I've wrongfully breached the contract, mediation would be motivated. I would say, let's go for mediation. And like I said, the anomaly I pointed out, I won't reply to the first notice. I'll wait for the second notice to come out. And when the second notice comes, I'll again sit on it. And I would stretch it by a month and a half or something. And then suddenly say, oh, no, I'm ready for mediation. Then take it out to 3 months, then probably give some, like in layman's term, and excuse my unparliamentary language, give a lollipop and say, okay, no, I think we should come to a settlement and take it to another 2 months. And that way you got to play with that money for another 5 months. And sometimes the interest is not even awarded. Even if he puts that simple money in interest in the bank, he'll get 5.5%. In FD and any other mutual fund or something, he'll get 10 to 12%. Or if he gives it in a form of NBF, like what NBFCs do, interest as much as 20, 30%. So this is something which the courts need to look at, according to me, because it can be misused. That having said, thank you, the university. Thank you, Mr. Subramanya. Thank you, Mr. Parmeshwaram. Thank you, Ms. Selvamuni, for having me here. I hope I have utilized your time and justified your time. And yeah, it was an honor being here. Thank you so much. And I will be taking any questions that you guys have.
Thank you very much, sir. That was truly a message to ponder on. So now we are open to question and answer session. So kindly post your queries in the chat box. And this session will be coordinated by Mateen Khan from 5th SEM LLB.
Thank you, Bhumika. Thank you, sir, for this informative session. Now, with your permission, may we begin with question and answer session, sir?
Sure, please.
Okay. Sir, with your permission, can I read out the questions?
Yes, please.
So first question is from Avantika. In your opinion, how has mandating mediation as precedent to litigation impacted persons with respective to their belief in respective system?
Sorry, can you just repeat the voice crack?
So
Is it written out here? Yeah. What are you saying? Can you read? How has mandating mediation as a precedent to litigation impacted persons with respect to their belief in the respective system? Well, that's a very philosophical question, I must say. But yeah, it does act as a deterrent because imagine someone with me with who just has a case of 3 lakh 10. Because that extra 10,000 he has now been validating of this. He has come under this and he has to go through that. And we all know legal costs are going through the roof. And it's not only the lawyer's fault or something, because I would say this profession is the harshest profession and we all have to make our money. And even the cheapest lawyer, you go, even he has to run his house. So he's going to charge. And this is going to deter the client as well, because the client would sometimes be like, I can't afford it. Even see, we go to mediation, there'll be 7, 8 hearings then we go for a summary suit, or depending, that's just a recovery suit or something, go for summary suit or some other suit. The costs are going to be so invariably high that you may even like to settle at half the amount. You know what I'm saying? So it does act as a deterrent, but also if you look at the other way, parties may be willing to settle it in the first go itself. But if that was the case, I mean, that's the personal experience that I've seen through years of negotiation. If the parties have to settle, they won't go to court, or they won't register to a mediation center. They'll get on a call and do it. And if it's not happening, it doesn't matter whether you go to a center or to a court. Unless a final decision after appeals and appeals has been given, no one's going to clear that money.
thank you, sir. So we have next question from John. So according to how efficient is pre-institution mediation?
I mean, like I said, the mediators are doing their job greatly, but like I said, the floodgates have opened up. And with this case, which has recently happened since August, I can only imagine there would be floodgates opening up, dearth of trained mediators. Because now suddenly there is a situation where you need more mediators. But how do you filter out quality mediators? You might be just been hopping on or empaneling them. But then a mediator plays a very important role. He's not just there to listen, and just because his recommendations are not binding does not mean that he does not play an important role. He has to be a very skilled professional. Sorry, I can't hear you. You're saying something?
No, sir.
Okay, sorry. Oh, so like I said, he has to be a very skilled professional to help the parties to come to a settlement. And if he's not that, it's just a wasted procedure. Like I said, 5 months gone here already. 6 months actually, I would say. Mutually extendable up to 5 months, then another initial first 1.5 month in getting the case thing. So 6-7 months are gone here. Then you draft your plane, then it gets filed. Almost a year is wasted out here. So it is efficient, but in light of this decision, God knows how it is going to be planned out. We have to see. I mean, I don't want to jinx it or demoralize anyone. Our country is doing a great job in doing it. And you should actually, I'm amused, like especially when I came back from the UK and I was amused seeing lawyers are doing 10 cases a day. So we have a separate level of talent and our own level of X factor. But how it plays out is something which we have to see, and we should just have some faith in our judicial system that they will, given some time, will come out with a justifiable solution.
Thank you, sir. So we have next question from Sejal. So in mediation, there is no discovery process like there would be in normal court case. So the party relies on information from other party to help prove their claim. There is no formal method. Isn't the chance for the fake information high?
I mean, yeah, maybe. One is that you're blindly relying, and unless something is going on, like I mean, even if that happens, like I said, like okay, so the mediation bill also is saying the same thing, and even if you read the Commercial Codes Act, the same thing, that any settlement that has been arrived at will be treated as an award under the Arbitration Act of Section 13. So now if you say it is to be vitiated by fraud, or like if you get to know that a false information was supplied to you or the mediator, then obviously you can have it vitiated under the allegation of fraud or misrepresentation, which will lead to even further consequences. But yeah, like you said, every party coming with clean hands is something which is a concerning factor. But we should always assume that everyone's coming in with good faith to negotiate or settle. And that's where the job of us as lawyers kicks in, to look at the genuinity of the document or to catch a person who may have ill bona fide faith. So that's where the client is paying you for. And you need to be good at catching that, or highlighting any anomaly or anything that you notice, and you highlight it and you put it. You have to put it to the mediator that this is something which may be a fabricated document. And see, again, mediation, no one's forcing you to settle. If you feel it is fabricated, you say, boss, this mediation is gone. And you go to court.
Thank you, sir. So next question we have from Likith. So if the dispute cannot be resolved in the mediation, then the cost given for the mediation will have been wasted. Looking into financially, so is mediation effective as such?
See, there is not much cost. Like if you see if you see the schedule, it has listed the amount that you have to pay. Like initial, like if you come to schedule 2 mediation fee, it says that from 3 lakh to 10 lakh, the mediation fee is 15,000, 10 to 50 is 30,000. So it's a very minimal percentage, and this money has to be split between both the parties. So I'll tell you the procedure. I'll tell you something what happens for me. Today, I have to go to mediation center. I'll file a claim, and I'll fill in 1,000 rupees. That is the initial form. Then they'll send the notice to the other side, like I said about rule 3. Then only when they agree to do it, okay, like today your claim is between 3 to 10 lakhs. The thing is 15,000. You both pay 7,500. So the costs are nominal, but yeah, it will be wasted if you don't go. So it's just an additional burden, but not that much of an additional burden, especially for high litigating clients. Like if you go to commercial cases, high value commercial cases of more than like 3 crores, the mediation fee is 7,000, so not much to lose. But yeah, for a low value claim of 3 to 10 lakhs, the percentage of the costs might be a bit high. That's why between this, it's very likely to settle. Like I would always suggest people to settle if it's below 10 lakhs.
Thank you, sir. So next question we have from Shivani. So how to assure the confidentiality?
Well, confidentiality is always maintained, like how you do in arbitration as well. Everyone is bound by confidentiality. All your offers and all that you make is without prejudice. But a good thing, now I'm even browbeating mediation, but in such things, like if you look at as commercial lawyers, even though it is a without prejudice offer, you get to know what is their low point. But at a strategic point of view, you get to know what their low point is, even though it's a without prejudice offer and you can't show it in court. Or it is a with prejudice. Like in UK, what we do is sometimes we give a with prejudice offer, so that if they refuse it, and tomorrow, like imagine I offered you, instead of 2 million for a claim of 2 million, I have offered you 1 million pounds. You have rejected it, but I made a with prejudice offer. I will show it to the court when the case is done. When the case is done, and the case also awards him only 1.1 million or 1.2 million, I will say that 2 years ago I'd offered him the same amount of 1 million. Had he taken this extra litigation, costs wouldn't have come. That's when the cost consequences ensues upon the winning party. And that's where the normal rule of costs follow the consequences is departed from.
Next question we have from Sukrita. What are the driving factors for this?
Like the driving main factor, I would say, it's a win-win situation. There is a chance for declogging the courts and also the harassment for the parties. Like if you genuinely want to settle, and you have good mediators who can help you settle, you can go through the rigors of years of litigation, because as we all know, it does not stop at the trial stage. There'll be an appeal, there'll be an appeal of an appeal, there might be a revision, there could be 10 things, and once it goes to court, it may take years before you see any penny of it. And like I said, interest component, interest is not mandatory to be given. Sometimes it is only given from the date of judgment to the date of execution. Then what do? Your money is just lying there blocked. Today, as a claimant, I'll tell you from the claimant's perspective, today someone owes me 1 crore. I'd rather take 75 lakhs today rather than wait for 10 years and get 1 crore 10 lakhs. You know what I mean? I'd rather, even if I put that 75 lakhs in FD today at 5.5% rate, in 10 years it's double. So I skip the harassment also and I get more money. So that's the thing. It always, an ADR is a way to encourage, but like I said, you should encourage but not force it down their throat.
Thank you, sir. So we have next question from Adarsh. So how effective you think that private mediation is going to be in the coming future?
See, like when you say private mediation, as you're not going to go to an accredited mediator. Otherwise, all mediation are the same. If you want to get it towards truly private mediator, like how I want to name, but really big family of this country did it in their family disputes. So maybe all high net worth individual families do that. They get an elderly to do it. Or even if you go to a market here, which are big, the eldest in the market, you might be the eldest guy, and they respect his decisions. That is what used to happen back in the day, as I mentioned at the beginning of the webinar. So it is going to be effective, but then again, now if you want to allege fraud and all, how do you do it? Because it's a private mediation, no one has seen it. So you're also assuming the risk. Maybe you're scared of not going out and not letting the markets know what is happening. Maybe you're a listed company. Maybe your family owns 80% of that listed company. And if this news comes out, the markets might tank. So anything can happen. So in such a way, you might choose private. But then again, you can't allege things like fraud and all, because who knows what has happened there? You don't know what has happened. It's just yours. It's just he said, she said. So it is something which, I don't know, it's just case by case basis. I mean, no one can say anything about it. Just make sure you get a very knowledgeable, empathetic, skilled mediator who has a track record, and you have lawyers who can negotiate really well for you.
Thank you, sir. This was very informative session, and thank you for clearing all our questions. And now we'll end with question and answer session. Thank you, sir.
Thank you, everyone. Thank you, CMI University. Thank you, Mr. Subramania, for honoring me with this opportunity. I'm really grateful for you bestowing your faith upon me. And sorry, it's Dr. Subramania. I'm really sorry about that. And Dr. Parmeshwaram and Ms. Selvamuni. And Ms. Selvamuni for coordinating with me as well. Thank you so much. You guys are doing a great job. The university is achieving new heights by the day. And I wish you guys all the success. And if students have any issue with mentoring or doubts into the profession, please don't hesitate in reaching out to me. You can hit me up on LinkedIn. Not at all an issue. And yeah, please don't call me sir. The first thing which I went when I was going to be a barrister, the first thing my professor was a very decorated QC, now a KC. That's a Queen Counsel, but now as the unfortunate death of the Queen, it's become the King's Counsel. She told a very beautiful thing to me, that we are all members of the same profession. So there's no sir, no ma'am. We all are equals. If you want to give someone respect, you can call them by Mr. or Mrs. or Miss, as the case may be. But yeah, even I don't like the sir culture. Like, I can't say to someone else, if someone's elder to me, I myself do call them sir. But with me, I like to be delegated as Anurag or Mr. Katarki, but I'm not that old, so just call me Anurag.
Thank you very much, sir. Gratitude for all that we have leads to abundance in all that we desire. Now, I would like to invite Shana from 9th semester BLLB to deliver the word of thanks.
Thank you, Bhumika. I, Shana Stanley, on behalf of CMI University, consider it a great privilege to deliver this vote of thanks to all the people who were involved in making this webinar possible. This being the 9th lecture series under the Center of ADR in CMI University, we are grateful that the center has arranged for such lectures to keep the students and faculties informed with the latest developments and thereby become instrumental in contributing in furtherance to the alternate dispute resolution in the country. I first of all would like to thank our chief guest, Speaker Advocate Anurag M. Katarki, who, despite his busy schedule, found time to address the students of our college and answer their queries. So your lecture has given us insight about the moving importance of alternative to an obligatory form and the fact that in today's India, alternate dispute resolution methods have now been recognized as a conditional precedent. Once again, thank you, sir, for sharing with us your valuable insights. We look forward to learn from you in the future as well. I would also like to thank Honorable Chairman, CMR Group of Institutions, Sri K.C. Ramamurthy, sir. I also thank all the university authorities, and I also thank respected Dean, Professor Dr. T.R. Subramania, sir, who has supported the students in all their endeavors and has steadfast support for the program. I also thank our beloved director, Professor Dr. Vijay Pranishan, sir, and also Advocate Vidya Salomani, ma'am, for their endurance in arranging this webinar for students with great zeal. I also thank all the faculties at CMR University for their presence and support, and last but not the least, all the fellow students who attended this webinar and helped in making it a great success. Thank you one and all once again.
Thank you.
Thank you, everyone.
Yeah.
Pleasure meeting you all. Hope for such future lectures as well. And next
Thank
time,
you.
hopefully.
Thank you very much.
Kind words. I, on behalf of the Center for Alternate Dispute Resolution, thank you all for joining us here today. I wish you all a pleasant day ahead. Thank you.
Thank you, everyone. Take care.